My name is attorney Kathy Evans-Williams, and I am the managing attorney of the Evans-Williams Law Group. We practice estate planning and real estate, business formation, and family law. And what I'm going to do today is specifically talk about estate planning. And in particular, what is it? And how does it apply to me? Leaving my legacy. So let's go. First, I want to define estate planning for you. It's actually the process of certain death and the possibility of mental incapacity. So we know for sure we're going to pass away. That's a given. We don't like to think about it sometimes, but it's a fact. So that's not even a question. But estate planning is also what happens if we're here, but we can't manage our own health care or business affairs. So that's what estate planning is all about, those two things, planning for certain death and possible mental incapacity. In addition, it is a process that makes you talk to a lot of different people, right? So it involves a lot of different professionals. You need to talk to your attorney, you need to talk to your insurance person, your investment person, your life insurance person, your accountant. So it's a group of professionals that you need to speak with, including yourself, to help you establish this estate plan. And then finally, what does it do? It helps you direct your assets to the people you want them to have, to the people that you want to have your assets when you want them to have it. And it also allows you to name somebody who's going to take care of your children or your children's assets or your minor grandchild's assets if you can't or their parents cannot. And then it also allows you to avoid probate, helps you pay less taxes, and most importantly, it leaves a roadmap to your loved ones. So, really, when you pass away, your family members are going to be sad, and that's one thing, but they don't have to be sad and confused. So what I want to do is kind of give you some tools, give you some information to help you leave a legacy instead of some drama. All right. It's really an easy process, 3 steps, 1, 2, 3. First step, gather your information. You're going to gather your information regarding your income, your debt, your equity, your liabilities. Who do you want to leave stuff to? Who's going to receive your assets? And then you also want to think about who's going to be your fiduciaries. And your fiduciaries are the ones that you're going to trust to make sure that your plan is carried out. Your executor, your agent, your trustee, and you'll hear me talk about that a little bit more later. Once you get all your information together, then you want to define your goals and objectives. What do you want to do? Do you want to leave stuff to your children? Do you want to leave stuff to your spouse and then your children? Are you in a blended relationship where you want to make sure that all of the children are taken care of, but the children that were born to you perhaps have a different need than the children who were not born to you? What do you want to do? And sometimes when you start looking at what you have, you start thinking about what you don't have, right? And so maybe one of your goals is to get more stuff. So what do you want to do? What are your objectives? And then once you define your goals and your objectives, then you want to meet with the professionals to make it happen. So I talked about earlier, you want to sit down, you want to talk to your attorney, talk to your CPA, talk to your life insurance person. If you don't have what you think you need, talk to your investment person. So it's really 3 steps. Gather your income, your information. 2, define your goals and objectives. And 3, make it happen. So now, what I want to do is kind of tell you how you can make it happen. What tools can you use to make it happen? I'm going to talk to you about a testamentary will, a transfer on death instrument, land trust, living trust, and your powers of attorneys for health care and property. As it relates to a testamentary will, most of us have heard about that already. Somebody has passed away, you have a vision of going to an attorney's office and they are actually reading the will, right? And this is the document that says, this is what the person who has passed away had, and this is who they want to give it to. So that's really what it is. It's a revocable transfer. It's a document that says, when I die, this is who I want to have my assets. It doesn't really go into effect until you pass away, though. And you also, within your will, you have to name that fiduciary that I talked about, who's going to make sure that your will actually happens, the intent of your will actually happens. That person is called an executor. And so in your will, you're going to not only indicate what you have and who you want to give it to, but you're going to define who your executor is. So who is that person who's going to make sure that your wishes are actually going to happen? The thing about a will is that you have to be at least 18 years old, and you have to be of sound mind. I'm just going to spend a second on being of sound mind, because as an attorney, I've been practicing now for a long time. Let's just say that. And I hear all too often phone calls that come in and say, "Hi, Attorney Kathy. My mom is suffering from dementia, and I think it's time for us to get her will together." My friend, if your mom is suffering from dementia, it's too late for your mom to get her will together, okay? I've seen this time and time again. In order for you to create any of your estate plan documents, you have to be of sound mind, because it's a contract. And so you have to know what you're doing. And it is a process. And so you have to have enough energy and mental capacity to make it all happen. So you want to do it now, not later, because we never know what tomorrow is going to bring, okay? So I won't belabor that point, but you have to be of sound mind. And your children, when they call, I'm going to need to talk to you, okay? And if you're not of sound mind, I'm not going to be able to assist you at that time. All right, so let's get it done before that time. It has to be written. It can't just be, well, my family members know what I want. I'm sure they do, but it has to be written. It has to be legally witnessed, and all of these things create your will. Now, the challenge with the will is that it still may go through probate. So the question is, well, what is probate? Probate is that court-appointed process where the will is declared to be valid or invalid, and it's the process by which your assets are then transferred to your legatees or heirs. So in the event that you have a legatee, and let's say that you have 3 children and you've only named 2 people to receive something from your will, although you have 3 children. You have 3 heirs, 2 legatees. In your will it says, I'm going to leave everything to 2 of my children. Well, that 3rd child that perhaps hasn't made the choices that you would like him or her to make, that 3rd child can come into court and say, I contest this will. I should have my fair share. So probate allows someone to contest the will, and it also allows creditors to file claims in your estate. So the house that you paid off, that you worked so hard for, let's say that you were sick and you started to accumulate credit card debt and you weren't able to pay that credit card debt. Your creditors can file a claim in your estate and they will receive payment before your legatees do. So probate is not necessarily your goal, all right? And so a lot of people say, well, okay then, Attorney Kathy, I don't want to deal with probate. How can I get away from doing that? Well, probate, and I kind of want to backtrack a little bit, it can be costly. People say, I want to get away from it because it can be costly, right? And it can be not just costly as relates to money, but also relationships. So just imagine if you have 3 children and now they're all in court with their own attorneys fighting each other. It's not just about the money anymore. So it's costly, not just financially, but it's also costly emotionally. All of this becomes a matter of public record. So now all your family drama is for anybody to read and see. And it definitely reduces your estate. So the money that you have to pay to the attorneys to make this all happen is money that is not being given to the beneficiaries. So that's why they say, well, hey, I don't even want to deal with probate. How can I get away from doing that? And hopefully I made that clear. And for those of you who know what probate is, I know that whole explanation was for naught, because you already know how tough it is and how expensive it is and that you don't want to deal with it. So that was for the folks who didn't really know. So now, how do I not do that? How do I make sure I don't even have to put my family members through probate? Well, here's one way. The first way is you want to make sure that you complete transfer on death instruments. And what that is naming a beneficiary on all of your cash accounts, your investment accounts, your life insurance policies, your vehicles, anything that you can name a beneficiary on, you want to do that. That's called a transfer on death, or a payable on death, a TOD, a POD. And so anything that you name a beneficiary on, that passes outside of probate. That goes directly to the person or entity that you have named as the beneficiary. So you can also do that with your home. You can name a beneficiary on your home, and that document is called a transfer on death deed, wherein you can literally say, I have this home and I want to name X as my beneficiary. Now, one of the things that you always want to think about when you're talking about estate planning, whether it is your executor for your will or your beneficiaries for your gifts, is that you always want to think in levels of 2. So let's say you name someone, you have to think about, what if that person predeceases me? Or what if that person just doesn't want to do it, or just doesn't want to receive the gift? So you always want to think in levels of 2, okay? So as it relates to a transfer on death deed, as I stated, it allows you to name a beneficiary on your house, just like you would name a beneficiary on your bank accounts, or on your life insurance policies, or on your investments. And when you pass away, the property then goes directly to that person or people. Another way that you can avoid probate is by doing something called a trust. And a trust is an arrangement that allows a third party or trustee to hold the assets on behalf of a beneficiary or beneficiaries. And a trust can be arranged in many different ways. It's very flexible. And so what it allows you to do is say, I have this asset and I'm going to put it into my trust. And the person who is holding the trust, or entity that is holding the trust, is called the trustee. And when I pass away, I want you to read the trust agreement that I've put in place for you to distribute the assets. And so when you pass away, the trustee reads the trust agreement and they distribute the assets accordingly. So let's go to that next slide, and I'll be able to show you what it looks like. So this is what it looks like, how a trust works. First, you have the trustee. And again, that trustee can be a person or an entity. For example, if it's going to be a land trust, the entity that is the trustee is going to be a land trust company, like Chicago Title or Marquette Bank or any land trust company. That would be the trustee. If you're going to have a living trust, you are your own trustee. If it's a revocable living trust, and I'll talk a little bit about the differences between revocable and irrevocable in 1 second. But the trustee can be a trust company or a person. That company or a person holds the asset, and that asset can be a house if it's a land trust, or if it's a living trust, it could be a house and all of your other assets. And they hold those assets, and then once you pass away, the trustee then distributes your assets to your beneficiaries in the way that you have defined. So hopefully that picture gives you a little more clarity as to what a trust actually is. And so now I want to talk to you a little bit about different types of trusts. You have 2 main different types of trusts. One is an irrevocable trust, and the other one is a revocable trust. So I'm going to talk about an irrevocable trust first. An irrevocable trust allows you to not have your assets in your estate anymore, so that if you need to qualify for Medicaid, you don't have to count the assets that are in your trust. In order to do that, you have to relinquish management and control of your assets within that trust. So with an irrevocable trust, you no longer have management or control over those assets, and therefore those assets are no longer in your estate. The pro of that is you can qualify for Medicaid. The con of that is you can't change your trust. So many people say, hold on, that's a bit harsh. I don't want to just relinquish all of my assets. And I understand that. And so one of the things that you can keep in mind is you don't necessarily have to do that. Even if you're in a position where you need to qualify for Medicaid, and we know in order to qualify for Medicaid, you only can have like $2,000. there are some exceptions to those Medicaid rules. And so for one of those exceptions would be if you own a home and you say that you're going to return home, but you need to be placed into a nursing home or a care facility for a period of time. If your intent is to return home, then your house is probably exempt from the Medicaid assets. So there are different kind of exceptions as it relates to Medicaid. So an irrevocable trust isn't necessarily what you need. Another form of an irrevocable trust, though, is something called a special needs trust or a supplemental needs trust. And that's a trust where you would be able to place your assets for the benefit of a third party, a beneficiary who has mental incapacities or physical incapacities, or somehow is considered challenged in some way, such that they are receiving Social Security. So that if they're receiving Social Security benefits and you give them a lump sum of money, their Social Security benefits are going to stop until the money that you've given them runs out. And then how many of us know that if they run out, the government isn't going to automatically just kick right back in and start paying? So there's going to be a long lag time. So the way that you will be able to still give your loved one who is suffering from mental or physical differently abled, people, you would be able to place their money into a special needs trust or a supplemental needs trust. And again, by definition, the owner doesn't own those assets, therefore they're not counted as it relates to the government benefits or Medicaid. And so they can receive those assets in addition to the government assets, the government benefits. So irrevocable trusts, for some, work because they're okay with relinquishing their assets and the management and control of their assets. And for others, it's because they do need to set up a special needs trust. For a lot of people, though, they say, I don't want to release my management and control. I don't want to do that. And so you would be a candidate for a revocable living trust. And a revocable living trust allows you to maintain your management and control of the assets within that trust. You are able to modify that trust whenever you want to. You can amend it. Let's say you get another house. You can put the additional house into your trust. Let's say that you get more cars, more vehicles. Let's say that you decide that, the person that I thought I wanted to give this asset to, I don't want to give it to them anymore. Or let's say the person that you wanted to give the asset to has now passed away. And so you can amend your trust anytime you want to. In addition, it can become very flexible, meaning that let's say that you have minor children, and let's say that you have, $100,000 that you want to leave to your minor children. Well, if they're anything like the children I know, you don't want to leave an 18-year-old, even a 19-year-old, $100,000, let alone a 5 or 6-year-old. And so what you can do in your trust is say, this $100,000, I definitely want it to go to my child. But I only want, let's say, $10,000 to go to my child at the age of 18. And I want maybe $20,000 to go to my child once they've shown me that they have matriculated through college or whatever their chosen, trade is. So when they turn 22, 23, go ahead and give them some more. And then hold on to some of it because still they're young. And I want to make sure that they remember me at 30. So at 30, when I know that they're going to have more maturity and probably be able to know what to do with the funds in a better way, go ahead and give them the balance at 30. So that kind of flexibility comes with a living trust. All right. Now, the revocable trusts, there is the land trust that is just for land. And then there's that living trust that is for everything. So I kind of just grouped everything together. Let me just break it out a little bit. The land trust is specifically for land. You can only leave property, real estate in that land trust. And that's where you're going to have the land trust company serve as the trustee. With the living trust, you serve as your own trustee. So with the land trust, because some other entity is serving as a trustee, you're going to pay them for that. So there's usually an annual fee that accompanies the land trust. Not horrible, but it's just for the land and there's an annual fee. With your living trust, It's for your land and everything else, and there is no annual fee. And while you are alive, you are your own trustee. And when you pass away, because you've been thinking in levels of two, the successor trustee is going to step up, read your living trust agreement, and distribute your assets in the way that you've identified. The goal of a living trust is to fund your trust. And that means that you want to put all of your assets into your trust. In the event you pass away without having placed all of your assets into your trust, then you're going to need something called a pour-over will. And the pour-over will is that document that your executor is going to have to take to court to say, Judge, the person who passed away did have a trust, but this particular asset had not been placed into the trust. And so, Judge, I need you to give me the authority to pour this asset over into the trust, and then my trust agreement will take care of the rest. That's fine, but remember, anytime you go to probate, anything can be contested. Your creditors can file a claim. So the goal is to make sure that you put everything in your trust while you are alive. This next slide kind of shows you that you can name your trust as the beneficiary. So remember, I talked about making sure with your transfer on death instruments that you name somebody or something as the beneficiary. So on your bank accounts, on your life insurance policies, on your investments, you can name a person, which is fine, or you can name your trust. So let me just spend a second on what's the difference. If you name a person, then that money will go directly to that person. And as we talked about before, we really don't know what's going to happen to us, right? I mean, we're just walking in faith, and I might be incapacitated by the time you leave me some money. I might be on Social Security, and the money that you leave me might be a good $50,000. Well, if you give me a lump sum of money and I'm incapacitated, that dollar amount is $50,000, that might last me a little while. But as soon as I get that money, my government benefits are going to stop. The money that you've given me is going to be used up really quickly, and then it's going to take me some time to get my government benefits going again. If you had named your living trust as the beneficiary, however, in your living trust, you're going to say, if this person is incapacitated, I still want them to get this asset. And so instead of giving it to them outright, give it to them in a supplemental needs trust or the special needs trust that we talked about before. See how that goes together? So if you name your trust, you have greater flexibility, and you would want to make sure that you name your trust as the beneficiary on all of your assets. Some other considerations, I hear is, okay, Kathy, I don't really have a lot of money. I just want to put my son on my house. And that's fine, right? Because when you pass away, your son will own your house. That's not a problem. Except if there's a judgment issued against your son. Because if there's a judgment issued against your son, guess what else? That judgment is now going to be recorded against your property. Same thing with your bank accounts. In the event you add your child to your bank accounts, if there's a judgment that's issued against them, they can place that lien against your bank account. So that's not the best way to go about your estate plan. I do know that for a lot of people, you say that that's easier, and sometimes it works. I just want to make sure that you know, if something happens to that person that you've added to your house or added to your bank accounts, that whatever thing that happens to them happens to your stuff too, okay? So the other consideration that you want to think about is, maybe you want to ensure that your final remains are handled in the way that you really want them handled. Sometimes we get very emotional when our loved one passes away, and we wind up spending $20,000, on stuff. So you may want to consider, should I now perhaps define what I want and then perhaps pay for what you want so that your loved ones don't have to? So we've talked a lot about what happens to my stuff when I pass away. So now let me just spend a few minutes on what happens to me if I'm still here, but I can't handle my own affairs. So the person that you want to appoint legally is called an agent when we talk about power of attorney for healthcare. So that's the person who's going to be able to talk to your doctors about your medical records, tell them what you want or don't want, tell them what kind of medication you do want or you don't want, or you consent to or you don't consent to. So handle all of your healthcare affairs. With the healthcare power of attorney, you also get to, before you get sick, right, tell your family members and tell third parties what you want. So for example, you get to determine whether or not the quality of your life is more important than the quantity of years that you live, so that your loved ones don't have to try to figure it out. So that if the doctor says, you know, this person is now in an irreversible, incurable, has an irreversible, incurable disease or illness, and they won't get better, and their brain activity has ceased, and we are allowing them to live because we're, you know, they're on a machine. But if we were to turn the machine off, you know, they would transpire. So you can tell your family members before they have to make that decision whether or not you want life-sustaining treatment that is going to artificially prolong your natural passing. Or if you say, no, you know what, if that's the case, I just want to go on and I want comfort care. I want to be made comfortable. And that is going to alleviate the stress of having your family members trying to figure it out. If you say the quality of my life is more important than staying alive, great. If you say staying alive is more important than the quality of my life, great. Just make a decision so that your family members don't have to try to figure it out. Because again, that whole costly piece of it, if your son thinks one way and your daughter thinks another way, now they're fighting. And now that could be some of the issues that when you think about Christmas and you think about birthdays, and you know, they might not be able to get over one person saying mom should have been on, you know, this machine longer, and the other one thinking that I can't believe you're doing that to her. So just handle that piece. That's a power of attorney for healthcare. And then similarly, there's a power of attorney for property, which says if I can't talk to the mortgage company, if I can't talk to the electrical company, if I can't handle my day-to-day affairs, I'm going to put somebody in place who I trust, who can handle those affairs for me. So again, you always want to think in levels of two. In the event the first person that you name, that you trust, can't do it, then who? Always levels of two. And if you don't have this power of attorney for property or power of attorney for healthcare, you know, just like if you don't have the proper estate plan, you wind up in probate court. If you don't have the proper power of attorney for healthcare or power of attorney for property, you're going to wind up in guardianship court. Okay? And guardianship is where your loved ones may decide to fight. I could take care of her better. No, I could take care of her better. And the court gets involved. And the court then determines who's going to take care of mom, who's going to take care of mom's money, and of course, who gets paid? The attorneys. So power of attorney for healthcare and power of attorney for property, everybody needs. Okay, so I want you to, while you are thinking about this, I want you to think about your considerations, right? So you want to think about your financial information. What do I have? Do I have real estate? Do I have investments? You want to think about, do I have children? Do I have people who are depending on me? Have I thought about who I'm going to put in these roles? Who do I think can really do my trust, right? Who's going to serve as my trustee? Or I just want a will. And who's going to serve as my executor? Who are going to be my agents? Who's going to be my second choices for these things? So you want to think about that. Another consideration is, okay, this is what I have. Now, who do I want to give it to? And sometimes that is a challenge, because when we start thinking about our families and we start thinking about what we have, sometimes it's difficult to determine who we want to give it to. Similarly, sometimes it's difficult to determine who's going to actually handle our affairs. But you have to think about these things. And then you also want to think about, are there special considerations? You know, as it relates to taxes, nobody likes to pay, you know, more taxes than they need to. So how can I make sure that I don't do that? Or, you know, I definitely have a child who already has special needs. I know that I'm going to have to take care of that child. How do I do that? So when you start thinking about all those things, then you want to start thinking about, okay, what do I need? Do I need a will? Do I need a trust? Should it be a land trust? Should it be a living trust? Maybe I just need a transfer on death deed. I know for sure, Kathy already said I need a power of attorney for healthcare and a power of attorney for property. So I know I need that. But what about these other things? What do I need? And if I don't have them, what am I doing? Am I leaving a legacy or am I choosing to leave drama? Right? And so if you want to leave a legacy, you have to make the decision as to whether or not you're going to create your own estate plan, or if you're going to reach out to your professionals and allow them to help you create your estate plan. So hopefully what I've done is give you a lot of information to help you in your journey to leave a legacy and not leave drama. Thank you so much.